On April 6, 1994, President Juvenal Habyarimana's plane was shot down above the Rwandan capital city, Kigali. His death became the first of over 800,000 deaths caused in the Rwandan genocide. From April 6 until July 4, 1994, 85% of the members of an ethnic minority known as the Tutsis were massacred by fellow Rwandans. Throughout Rwandan history, there were two main ethnic groups: the Tutsi, the fighters and herders, and the Hutu, the priests and farmers. Intermarriage occurred between the two, and one's status could change.
More than 1,000 years ago, there came to the highlands of East Central Africa the Watusi, a giant race who conquered the agricultural natives of the region now known as Rwanda. The family of Prince Muikarago are preparing for breakfast. One of their many Wahutu servants has brought water with young palm leaves for hand towels.
It wasn't until European colonization that this flexible system evolved into an ethnic problem. As eugenics was widely accepted during this era, Belgians sent out scientists with scales, measuring tapes, and calipers. The Tutsis, who were taller and thinner, were deemed to be nobler than the Hutus, and thus the Tutsi warlords of old quickly became the puppets of the colonial imperialists. To keep the Hutus separate from the Tutsis, Belgians codified forced labor in 1924 for Hutus only. Furthermore, they introduced a census in 1933. Rwandans with 10 or more cows, correct body measurements, and verification from the churches were designated as Tutsi on their government-issued identity cards, which were to be used until death. The Hutu Manifesto, published during the Rwandan independence movement, reinforced these cards. The fact Hutus wanted known was that of 1.8 million Rwandans, only 250,000 to 300,000 were Tutsis, and that 15% of the population held the bulk of political and social power. Eventually, the tension built up until the country erupted into genocide.
Il est 16h22 à Kigali, dans le blindé de la FLM. Avis à tous les Guinéens qui nous écoutent. Oui, à tous les Guinéens qui nous écoutent. Le Rwanda appartient à ceux qui le défendent vraiment. Et vous, les Guinéens, vous n'êtes pas des Rwandais. Vous êtes ici les Tutsis, ils ont taillé archivés. Vous êtes ici les Tutsis.
An estimated 130,000 civilians partook in the massacre with machetes, clubs, and axes. After the Tutsi-led Rwandan Patriotic Front ended the genocidal campaign, Rwandans had to face multiple dilemmas. For one, the genocide decimated the population, and since many judges and judicial staff were Tutsis, the judicial infrastructure and government were virtually gone, leaving Rwanda incapable of punishing its citizens turned soldiers. The initial conflict was over, but out of it rose a greater challenge. Thousands had participated, so should all involved be sentenced? In search of a resolution, Rwanda set up the International Criminal Tribunal for Rwanda, the ITCR, and the National Court System for Genocidal Crimes. To streamline the trial process, the Rwandan government passed the first genocide law, establishing a 4-category classification system for genocide crimes. The first category, which had the strongest severity, consisted of organizers of the genocide and rapists. Those in this category were taken to conventional courts and sentenced to execution, but the remaining 3 categories, murder, manslaughter, and theft, were left to be tried in local Gacaca courts, a community justice system. These actions, however, did nothing to solve the prison crisis. A year after the genocide was over, there were 58,000 people in prison on genocide charges, and by 1998, that number had risen to 130,000 total prisoners living in prisons that were designed to fit a maximum of 12,000 people. As Times reporter Donatello Lorch said in April of 1995, there is no protection against the daily downpours, and many of the prisoners' bare feet are rotting from gangrene. Every day, 5 to 10 die and many more are taken to a local hospital with pneumonia and dysentery. Overcrowding, poor sanitation, and lack of food and medical care were also deadly, and among the guilty were the falsely accused. In December 1996, conventional courts and the national court system began trials, but after 2 years, only 1,292 genocide suspects had been tried. At this rate, it would have taken up to 200 years to complete all of the over 100,000 trials. So Gacaca courts, a centuries-old Rwandan tradition, were reformed as a way to speed up the trials, reduce the prison population, quickly rebuild the nation's social fabric, and reunify the fractured country. Gacaca trials were where community members and elders met to solve property, inheritance, minor injury, and marital disputes. But serious matters, such as murder, were judged by the king, not the elders. So how could this informal process be used to execute justice for crimes worse than murder? Beginning in 2002 and spreading nationwide by 2005, the Gacaca courts became the major source for compromise for genocide-related cases. These 12,000 courts tried these cases until June 2012 and tried over 1.2 million cases within less than a decade. These courts had 5 goals. The first was to reveal the truth about what happened. The second was to speed up trials. The third was to eradicate the culture of impunity. The fourth was to bring Rwandans back together. And the fifth was to prove that Rwandan tradition can solve Rwandan problems. These were run by at least 9 local judges and encouraged the participation of local community members, making ordinary Rwandans have a major role in the process of dispensing justice and fostering reconciliation. Since Gacaca courts have no prosecutors, cases are based off accusations from a civil party, usually the victim or relatives, and the judgment is reached by a majority rule of the 9 judges. All community members are encouraged to speak and give their account of what happened or provide alibis.
Kasane muri kumwe
oya ntabwo ngiye kumubona ko duhaguruka mu kabuga niho namusize aho ba konsiya duhagaritse niho namusize tumanuka ariko twinjira hose tuzagajaga ntabwo ngiye kumubona kuko nagendaga mu bantu bari imbere ntabwo ngiye kureba kandi batubwira bati nta muntu usubira inyuma.
Not all Rwandans love Gacacas though, and some shunned them for providing insufficient support. One such group was the approximately 200 to 300,000 women that were raped during the 3 months of the genocide. In the original system, rape constituted a Category 1 crime, a case to be carried out in a national court. But since many victims were dying from HIV/AIDS contracted via rape, the Rwandan government made the decision to send these cases to Gacacas in May 2008, as these cases made up 90% of the Category 1 crimes. Though moving them to Gacaca jurisdiction would help finish all the cases sooner, some victims felt betrayed since they could no longer keep their identities a secret. Furthermore, Gacaca courts didn't provide financial assistance to the victims as national courts would. But despite these problems, many still praise Gacacas for their role in mending Rwandan society.
Pourquoi? Parce que dans le procès Gacaca, c'est le procès du peuple et de la population qui se connaissent entre eux, qui viennent se mettre ensemble pour parler ensemble de ce qui s'est passé. Donc c'est un procès où la population qui se connaissent bien disent ce qu'ils ont vu, ce qu'ils ont rencontré et au cours des événements qui sont passés au Rwanda dans le génocide. Et ce procès Gacaca donc met ensemble et les retrouver tous les frères. Et ils se rendent compte donc ce qui s'est passé entre eux et celui qui est coupable. Alors on lui donne donc sur le projet Gacaca pour arrêter les mauvais sentiments de la discrimination. Oui. Vraiment après ce projet Gacaca, maintenant les gens, la population vivent ensemble, collaborent et visent surtout le bien avenir de notre pays, dans notre cher pays. Donc actuellement il y a une grande cohabitation entre les deux ethnies. Merci. Si tu as besoin d'autres informations, tu m'as fait signe, je vais les envoyer.